Thank you very much. Please be seated. When you're ready, also call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Arthur G. Watrous, Administrator, and the Estate of Arthur H. Watrous versus Porter Medical Center, case number 24 AP 229. Representing the appellant, the estate of Arthur H. Watrous, is John Evers, and representing the appellee, Porter Medical Center, is Baird Joslin.
Okay, thank you very much. Good morning, counsel. Please come on up. And if you would, for the record, before you start, introduce yourself and your client.
Thank you, Mr. Chief Justice. I'm John Evers, and I am here on behalf of the appellant, the estate of Arthur Watrous. This is a medical malpractice case, as the court is aware, and in every medical malpractice case, patient safety is paramount. Reasonable steps need to be taken to make sure that a patient is not subject unnecessarily to risks. In this particular case, involving the use of a chemical restraint, what that means is that Porter Hospital, the defendant, needed to take reasonable steps to ensure that Mr. Watrous would not be subjected unnecessarily to the risks of the use of a chemical restraint. The evidence in this case is undisputed that the standard of care prohibits scheduled or standing orders for a chemical restraint. It's also undisputed that the standard of care requires that there be some determination, some assessment that the patient, in fact, is in need of such a
Mr. Evers,
chemical restraint.
what's assessment mean? What do they have to do for an assessment? What are they assessing?
Sure. There needs to be some determination as opposed to simply following a schedule. So rather than in this case, it was scheduled every 4 hours. So rather than simply providing the medication at the 4-hour interval, there needs to be some determination by a healthcare professional that in fact it's needed.
And when you say it's needed, meaning that agitation still exists?
Needed in the sense that that the patient is exhibiting behavior that presents a risk either to himself or to others.
Then it's okay to give a second dose.
Well, it's yes. Essentially, the standard of care says in that circumstance, there needs to be, yes, it can be appropriate in that circumstance.
Mr. Evers, I look at this as trying to determine whether the jury was confused, because if they were confused, then it doesn't seem odd that they would have made the decision that they did. And wasn't it confusing for them when, I don't know that it was you particularly, but whoever did the opening statement said that the standard of care is the synonymous with the policy at the hospital. But then later during the trial, during expert testimony, your side backtracked on that and made concessions about the standard of care not being synonymous with the hospital's policy. I mean, isn't that enough to have the jury consider this and say they didn't establish their standard of care?
So I thank you for that question, Justice Carroll. I take issue politely with the notion that we backtracked off of that. This is an unusual case in that the standard of care was actually written down somewhere. Usually in medical malpractice cases, we rely on expert testimony.
Talking about the policy?
About the policy. So the evidence in the case is that it was, whether it was synonymous, whether the policy reflected the standard of care, whether it was based on the standard of care, and both of the competing experts in this case acknowledged that there was a relationship between what the policy stated and what the standard of care was. So I understand your question about could there be confusion, and certainly I think there was an attempt to inject that into the case, but the idea that in order to prevail on the standard of care, we, the plaintiff, needed to show that the policy did in fact establish the standard of care, that's an incorrect formulation.
And there were experts on each side, right, about the standard of care?
Yes.
And typical in a trial, they disagreed with each other. So was this maybe a credibility determination that is not for us to judge?
Fair question, Justice Carroll. They disagreed on some things, but they did not disagree. In fact, they agreed, and in fact, that's also in the policy, that there should not be a standing or a scheduled order for a chemical restraint. In this case, there was an order that was given that this medication should be administered every 4 hours. Everyone agreed that was against the standard of care. So on that one point, and our position in this case is that the court really doesn't need to look beyond that one point. Did we establish the standard of care on that point? Yes. The policy says that, and both experts, regardless of the policy, assume there's no policy, both experts said that was a violation of the standard of care. No confusion, no additional components needed. End of. Now, Judge Fenster, in his decision from which we were appealing, an explanation or justification that he offered was that, well, the individual who actually administered the second dose that the case is about wasn't the person who issued the order and didn't have the authority to issue that order every 4 hours, which respectfully misses the point. The defendant was Porter Hospital. Porter Hospital, through its agents, employees, servants, had an obligation to follow the standard of care. So we don't see that really justifies.
But Mr. Evers, when
Yes.
looking at the medical chart,
Yes.
he gets the first dosage at about 1 o'clock in the morning. They put an LN in his room to monitor him. Every 15 minutes, they're looking at him. He's sleeping. The medication's working appropriately. At 6:11, he's awake and agitated and aggressive. And that's when the second dosage occurred. So isn't that consistent with what everyone's saying is appropriate? That he can give, that a second dose can be given once there's additional agitation?
And the jury may have concluded that if they had gotten to the issue of whether there was a breach of the standard of care and whether there was causation. They never got to those issues. The first question was, has the plaintiff established or proven the standard of care? And they answered that no.
But don't you agree that the plaintiff, you have the burden of proof by preponderance of the evidence to prove the standard of care applicable at that time and place? That's your burden.
Right. And at the time that the order was issued, back in 12:30 or 1 o'clock, whatever it was, at that moment, when that order every 4 hours was issued, that was the circumstance that matters. And by issuing an order every 4 hours, a standing or scheduled order, that violated the standard of care. That was the standard of care that we're looking at. That was specific.
But the second dose wasn't given at 4 hours. It was given at 5 hours.
Well, it was, I think it was 4 hours and 20 some minutes or something like that. Not right on the dot. I absolutely agree with you. There was conflicting evidence as to when the dose was given and what the records actually reflect in the time right before that.
To follow up on Justice Carroll's question, doesn't that create some confusion to the jury as to what the standard of care is? Which, again, being at your burden, would say they couldn't figure out what the standard of care was.
If we're focused on whether an assessment was done, whether a proper assessment was done at that moment, if that's all we were focused on, I wouldn't disagree with that formulation, that there could be some confusion about that. But again, our focus is when this order was issued as a standing order, as a scheduled order. At that moment, that was when the standard of care was violated. Now, did we argue that there were other standards, if you will, of care involved in the case? Whether the assessment was proper, whether it was properly documented, whether vital signs were administered? Yes. And I guess the analogy that I would draw here is if we think about driving a car, every driver has an obligation to drive responsibly. Well, let's get to the specifics of a case. They run a stop sign and they hit somebody. Well, standard of care is you don't run stop signs. Standard of care says you don't drive too fast. Standard of care says your brakes should be in proper order. Now, does the jury have to conclude that every one of those standards of care, if you will, or is it enough to conclude that they ran a stop sign, standard of care says you don't run a stop sign?
But in a car accident case, a normal tort case, doesn't have a statute that lays out the 4 specific elements for a malpractice case, including the obligation of the plaintiff to prove by preponderance of the evidence what the standard of care is.
Agreed. And our position in this case is, as it relates, and I apologize for being repetitive,
No, don't worry.
to this idea of a scheduled or standing order, it's undisputed. Both experts agree that that violated the standard of care. You do not give standing orders, scheduled orders for a chemical restraint medication.
So why no decision by the judge when the case was charged to the jury to that effect? Was it requested? Did you request a ruling that it's undisputed as to what the standard of care is?
We did not make such a Rule 50 motion in effect,
Right.
Mr. Chief Justice. We did not do that. No.
Okay.
Unless
Could
there are any
you-
other, I'm sorry.
Could you have done that? I mean, if it's an undisputed fact, couldn't you have said, move for a matter of judgment as a matter of law, saying that the first element doesn't need to be given to the jury because as a matter of law, we've shown what the standard of care is. And the judge could say yes, no, or maybe.
I'm sorry, it's a question, could we have done that?
Yeah.
With the benefit of hindsight, Justice Cohen, absolutely.
Thank you.
And I wish we had, but here we are. Unless there are any other questions, I have reserved some time.
Sure.
Thank you.
Thanks very much. We'll hear from counsel for the appellee, please come on up. And again, before you start, if you would please introduce yourself, identify your client. No rush, no rush. That's all right.
Thank you.
Yeah.
May it please the court. My name is Baird Jocelyn, and I represent Porter Medical in this case.
Thank you.
I've tried malpractice cases before, and sometimes the question about duty is not in the verdict form. Sometimes it goes right to, did the defendant breach the standard of care? In this case, the judge put it as the first question on the verdict form, and I believe it was appropriate in this case. It's caused a lot of motion practice.
Isn't it appropriate in every case?
Sometimes it's not disputed, Judge.
Well, I mean, sometimes it's not done, but is
I
it?
understand. Oh, sorry, I didn't.
No, but shouldn't it be done in every case? That's the statute says there's 4 elements.
You-
So shouldn't those go to the jury?
You're exactly right about that. I guess I would respond that if the parties agree that they can combine it, which is what happened in my last trial, we took it out. We didn't include it. But if there is a dispute, it is absolutely appropriate to put it in because it is an element of what needs to be proved in a medical malpractice case. But I want to,
So, Mr. Jocelyn,
sure.
I'm really a little confused here. Is it undisputed between the parties that the standard of care is this medication is never on a scheduled order?
The experts agreed that this medication is not ordered on a scheduled basis.
So is that the standard of care?
That is one component of an entire standard of care. It's just one component, and it's also, I'm sorry, I didn't mean.
No, go ahead.
It's an argument about what you shouldn't do, but it doesn't establish what the standard of care is. And so in this case, what is the question? The question was, did the estate prove the standard of care? And what the jury got was a charge from the judge. The judge said, what is the standard of care? It means the degree of knowledge or skill possessed by, or the degree of care ordinarily exercised by, reasonably skillful, careful, and prudent healthcare providers engaged in similar work under the same or similar circumstances. And that's super important here. And Judge Fenster really weaved that into his decision about what were the circumstances. You had 2 very different stories in this case. The plaintiff was claiming that the patient was asleep at the time of the second administration. Nurse Sanders, who testified at the case, he's the one that administered the second dose. He said the patient was very, very agitated, very combative, not able to be controlled.
But doesn't that go to the merits, not the standard of care, which is the issue here?
I would suggest no, Judge, because the question is, did the estate prove the standard of care under the same or similar circumstances? The jury was actually forced to determine what the circumstances were, and that would be involved in the standard of care. The judge charged that.
Yep. So there was no dispute then about the order that said that, I forget how it's phrased, but the word scheduled is used. There's no dispute about that. And there's no dispute that a second administration of the drug was given as would be, not PRN, but as would be applied under a scheduled order. Are those two things correct?
So the order said Q 4 hours. And Nurse Sanders, who got called in to deal with the patient when the patient got agitated the second time, looked at the order and read it as needed.
Well, I read that, but that's what the witness said. But what was written down was it was written as a scheduled order. There's no dispute about that, right?
It was written as Q 4 hours and interpreted as needed.
So isn't your argument here that the order had nothing, it didn't cause any harm? Isn't that really the argument?
Well-
Because if there's no dispute about this, what the order was, then it seems to me your argument is a causation issue.
No, Judge, what I'm talking about is like the first question, did the estate prove the standard of care? And there were competing testimony by the two experts. Their expert testified that it has to be a one-time order every single time, and that the patient needs to go through some sort of formal evaluation every single time. Our expert testified that you can order on an as-needed basis. Our expert testified that a second evaluation is not necessary if it's determined that the patient is agitated, combative, and unable to be controlled.
Well,
Those are-
isn't that what the evaluation is? Whether or not the person is agitated? Isn't that it's in the record, that's what they're looking for. They're not going to do a complete physical on the person. They're going to see, is the person agitated or not agitated?
I don't think that the plaintiff's expert actually articulated what that evaluation was. And in the end,
Well, it's in the nurse's notes, isn't it? I mean, and in fact, I thought the judge allowed the jury to ask questions at the end of every witness. Is that right?
that's correct.
Yeah. So after, I think it's the plaintiff's expert, they sent a question back, can a delirious patient go from sleep to, I can't read my note. I'm not sure what exactly, I'm assuming it's combative or something like that in 10 minutes. I thought that was a very interesting question. And the answer was yes, it's not infrequent. So that sort of explains the nurse's notes, doesn't it?
And I'm sorry, Judge, what is
What's the question?
yeah.
Well, that, I agree with you. That does not really, I was responding to something that you said. And now I don't remember exactly what you said.
All right.
So we could start
All
over.
right.
That's the way.
Okay. So I also want to point out that credibility is an issue in every case, some more than others. And in this particular case, the court was charged about you can disregard the entire testimony of a witness if they've contradicted themselves. Dr. Vagela, their expert, actually did contradict himself, not on the issue of standard of care, but about causation issues when the aspiration event occurred. He testified in his deposition that the aspiration event occurred between the first administration of Zyprexa and the second. Later, after we filed a motion, he changed his testimony to say the aspiration occurred after the second administration. If there's a credibility issue for a witness, the jury's entitled to throw the entire testimony out.
Doesn't that go to merits, not standard of care?
If the jury is considering what the standard of care is through the words of an expert witness, and they determine that witness is not credible, I would say it's relevant to the first question, Judge.
So go back, if you would, to the statement you made a few minutes ago that the undisputed between the experts that a scheduled order for this drug was not appropriate. You said that's not the standard of care. What do you mean by that?
So our expert testified that as needed orders complies with the standard of care, but also that if there is an order for medication and it's on an as needed basis and there is a patient who is agitated, it is okay to give a second administration.
No. I'm not asking about what your expert said. I want to know why you think, or what's your position that this is not the standard of care. I think that's how you put it.
It doesn't establish an entire standard of care. It's the same.
What do you mean by entire standard of care
So
in a medical malpractice case?
Sure. What we're focusing on here is the second administration of Zyprexa. There's no complaint about the first administration of Zyprexa.
Right.
There's no complaint about the approach.
Right.
The complaint is the second. So what is the standard of care for a patient who is combative and violent and unable to be redirected at this particular time, taking into account the entire
But you said complete standard of care. Where's that come from? Doesn't this depend upon what the complaint says? Aren't we anchored in any case to what the claims are that the plaintiff makes and what the defenses are that you raise in order to determine what it is that we're talking about in this case, a standard of care?
So I would suggest that the order itself does not establish the entire standard of care. There's more to it.
But what do you mean by entire standard of care? That's what I'm not getting. Can you give me a definition?
Well, the jury isn't given a definition. They're just given a guide about how to determine it. They get the standard of care from the
Well,
expert.
the jury they got a definition and the charge about what the standard of care means.
Correct. But then when they have to establish whether the plaintiff proved the standard of care, not a standard of care, the standard of care. And I think that they probably were confused because at one point they're hearing that the chemical restraint policy and the standard of care are one and the same. Then they heard from the plaintiff's expert, well, you have to do a formal evaluation of a patient before the second administration, where the chemical restraint policy itself said you have to do a formal evaluation of the plaintiff within an hour after the administration of the medication.
But does that go to the causation then, or whether there was a violation of the, quote, standard of care, which is not to issue the order on a scheduled basis?
No, Your Honor, because they have to know what the standard of care is collectively and as a whole before they make the determination whether there was a breach and whether the breach resulted in an adverse outcome.
So I thought it was undisputed that this order not be written or given on a scheduled basis. And correct? But when the nurse gave the second prescription, did it on a PRN basis rather than on a scheduled.
So I guess it was, both experts agreed that this medication should not be administered on a scheduled basis. Correct.
Right.
But that is.
But that's not the standard of care in your argument. Is that correct? Because there's other things. I'm just trying to understand it because I think the Chief Justice asks a question that is critical for me to understand. If that is not the standard of care, and there's other components, what are those components?
It doesn't establish the entire standard of care. And so it includes evaluation of the patient. It includes the facts and circumstances. And it includes the fact, does the patient need to be controlled to protect the patient from him or herself or others? All of this goes into it. And the experts addressed these sorts of things, but the jury was entitled to consider, did the plaintiff prove the standard of care, not a standard of care, the standard of care. And the defendant expert had different opinions than the plaintiff expert. And that fact alone indicates a dispute as to exactly what the standard of care was, the standard of care, not a standard of care.
And your argument is that that came down to a credibility issue.
Absolutely.
Okay. Thank you, Mr. Jocelyn.
Thank you. But is time expired?
No.
No, not yet.
If the court has any further questions, I'd be happy to address them.
I don't see any hands.
Okay, thank you. Thank you.
How much time does the appellant have, please?
Appellant has 4 minutes, 6 seconds remaining.
I would like to address this notion of the complete standard of care. I think the timeline is really important to keep in mind. There are different points along the relatively short period of time, essentially about 12 hours, that are involved in this case. But if we focus at what I'm going to call point 1 in time, which is when the order, the scheduled standing order every 4 hours is issued. If we look at that moment, those circumstances, what was the relevant standard of care? The relevant standard of care said you don't order this medication on a scheduled or standing basis. Now, a lot of the discussion jumps then to what happens about 4.5 hours later and whether there's a different standard of care or what the standard of care was in that moment. But if we go back to point A or point 1 in time, the standing order, scheduled order violated the standard of care. If we accept the appellee's argument that, well, it was a credibility contest, okay, so they don't believe the the plaintiff's expert, so what's left in the case? What's left in the case is the defense expert's testimony, which the printed case, page 92, the hospital violated the standard of care when the Zyprexa as a chemical restraint was ordered on a scheduled basis. Answer, right. So that is the standard of care that relates to that moment in time that we're focused on. As various members of the court pointed out, how that order was interpreted, whether it was followed, whether harm flowed from whether it was followed or interpreted some other way, really are issues that relate to breach and causation, not to whether the standard of care was established. That's all I have.
Okay,
Thank you.
thank you very much. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for 10:45 this morning.